time and we have a quorum. I call to order the meeting of the AJLSP. Item 1 on the agenda. Information paper issued since the meeting on the 16th of December last year. An information paper has been released by the Secretariat since the previous meeting. Please refer to the schedule for the details. Item 2, items for discussion at the next meeting. Please refer to CB brackets 2190-2025-01. This is the list of outstanding items for discussion. I and the Deputy Chairman have met with the administration as well as the Judiciary on the 24th of January, Friday, concerning the work plan for the panel in this year. Subsequent to the meeting, the list of outstanding items for discussion has been updated and is attached in the latest agenda issued on the 6th of February. Please refer to item 17 of the list, that is Secretary for Justice's role as protector of charities. At the work plan meeting, the administration said that the Secretary for Justice's role as protector of charities has been reflected in the swift actions taken up by the DOJ recently, and the administration proposed that the item be deleted. Do members agree with this proposal to delete that outstanding item? Dr. Junius Ho. Chair, I think that we don't have to remove the item. As the protector of all charitable organizations in Hong Kong, the burden on the Secretary for Justice's shoulders is heavy. Allow me to quote Mr. Paul Jie on this. He has been following up the cases of, say, like a China Cam very closely, but I think the progress is slow. Some progresses were made recently, but the DOJ has yet to give us a full picture of the cases. At this time when the fiscal position of the government is tight, the role of the Secretary for Justice's role as protector of charities is even more important, especially the utilization of public money. That would affect Hong Kong society as a whole. So I think we should keep the item on the table. In any event, the list is not that long. Thank you. I will convey Dr. Junius Ho's request to the DOJ. Now, according to the list of outstanding items for discussion, we will hold the next regular meeting at 2:30 p.m. on the 14th of March. The administration has proposed discussion of extension of measures of allowing Hong Kong invested enterprises to adopt Hong Kong law and allowing Hong Kong invested enterprises to choose for arbitration to be seated in Hong Kong. Moving on to the next item, promoting the development of the legal profession in Hong Kong. We will now invite the administration, the representatives of the DOJ and the deputations to come in. For this item, from the DOJ, we have Dr. Horace Cheung, Deputy Secretary for Justice and Secretary for Justice. Mr. Llewellyn Mui, Solicitor General, Ms. Leona Cheung, Principal Government Counsel, Ms. Lorraine Chan, Deputy Solicitor General, Ms. as the Leung Judiciary Administrator. First of all, I welcome deputations and representatives to join this item. Please speak into the microphone in front of you when you speak. If necessary, you may use the headset. For Channel 0, you'll be listening to the floor. Channel 1 is the Cantonese channel, Channel 2 is the English channel, and Channel 3 is the Putonghua channel. I remind deputations who are here today, when you put forward your views to the panel, your speech will not be protected by the Legislative Council Powers and Privileges Ordinance Cap 382. Nor will your written submissions be protected by the safeguard under that ordinance. First of all, I will invite Dr. Horace Cheung, Deputy Secretary for Justice and Secretary for Justice, to walk us through the paper briefly. And then I will invite deputations to speak. Each of you will have 5 minutes to speak. Whether there is 1 or 2 representatives, each organization will only get 5 minutes. For other views, please submit them via written form after the meeting. Thank you, Chairman, for inviting me and my team to attend today's meeting. We are pleased to listen to members and the trade's views on how we can promote the development of the legal profession. Before listening to your views, I will first briefly introduce the landscape of the trade's development. The legal profession in Hong Kong comprises solicitors and barristers. They can practice in various areas of law, including litigation, arbitration, and mediation. All along, we adopt the regulation by the trade approach. According to the Legal Practitioners Ordinance, Cap 159, the 2 professional bodies, namely the Law Society of Hong Kong and the Hong Kong Bar Association, are vested with the power to regulate solicitors and barristers in areas such as practice, conduct, discipline, examination, and continuing education by way of subsidiary legislation. The law also stipulates that rules and regulations made by the 2 bodies require the prior approval of the Chief Justice and the Court of Final Appeal. Both bodies must exercise their powers and fulfill their roles independently according to the law. Now, the 2 bodies play an irreplaceable role in terms of the developments of the trade. Reforms and enhancement measures must be proposed by the 2 bodies. I'm not saying that the DOJ doesn't have a role to play. On the contrary, as usual, the DOJ will continue to work closely with the 2 professional bodies through policy support and initiatives. We will help create an environment favorable for the development of the legal profession and create more opportunities for practitioners. We will help drive consensus and implement reform measures which are beneficial for the trade's development. In terms of ADR or alternative dispute resolution methods, riding on our unique strengths under one country, 2 systems, we will promote our legal and dispute resolution services on all fronts. In the 2024 policy address and also in our policy initiatives, the commitment has been fully reaffirmed. In terms of arbitration, the IOMAT's headquarters will be established in Hong Kong. It is expected that it will be fully up and running within the year. Now, last December, the legal authorities of the three places have formulated a standard on mutual recognition of arbitrators' qualification, and also we have published a register of GBA mediators. We will continue to drive the development of the disciplinary framework and the accreditation framework for mediators to consolidate our role as a mediation hub. Now, in the government contracts, we have added mediation first or mediate first pledge. It has come into effect in this year, or rather the 16th of February. And also, we will launch the pilot scheme on community mediation to nurture a culture of mediation in the community. In terms of GBA mediation platform, the three authorities have issued a GBA mediator code of conduct best practice and also guidelines on accreditation. We will strive to announce the first batch of recognized GBA mediators in 2025. And also, we will enhance convenience for parties participating in arbitral proceedings in Hong Kong as a regular measure. In terms of lawyers in the GBA, many Hong Kong and Macau lawyers have obtained a GBA legal professional license and can practice in the 9 cities in the GBA. So far, 550 Hong Kong and Macau legal professionals have obtained the lawyer's license in the GBA. These lawyers can represent their clients in court in civil litigations, civil matters and litigations. By practicing in the GBA, these lawyers can accumulate experience. Our lawyers are multilingual with a global perspective and training in the under-law system. They can provide a one-stop cross-disciplinary legal professional services for GBA clients. We will continue to support lawyers' developments in the GBA. To conclude, we will continue to work closely with the 2 legal professional bodies and the leading ADR institutions. Through today's meeting, we would like to hear your views on how we can consolidate Hong Kong's position as a regional mediation and arbitration hub in Asia. Thank you, Dr. Horace Cheung. I'll now invite deputations to put forward your views. First, Hong Kong Youth Legal Professionals Association. Respectable Chairman, Dr. Horace Cheung, Principal Government Counsel, Solicitors General, Deputy Solicitor General, Judiciary Administrator, members, fellow deputations, good afternoon. I am the representative of the Youth Legal Professionals Association. I'm a barrister. Now, allow me to separate my views into macro and micro views. Macro speaking, there are fewer and fewer companies coming to Hong Kong to list. Many lawyers previously engaged in IPO have now changed tack to litigation. Now, when the macro environment is bad, there are lots of winding up procedures as well as calling back of loans. So there are more businesses in these areas. So despite the decrease in the number of IPO cases, we have more businesses in other cases. Let me give you an example. I'm personally dealing with a case. I am offering legal advice to my clients. That is a litigation set in the US. That's a supermarket chain store. The supermarket ordered products from the US, and the products are processed in the mainland. So naturally, my client chose Hong Kong as a seat for arbitration and litigation because my client is confident in the common law system. This is our strength. However, my client chose Hong Kong as a seat of arbitration because of our proximity with the mainland. But what about 10 years later? Will Hong Kong still be their preferred seat for arbitration? Now, some factories have been moved to Bengali already. So the processing part of my client's operation has been moved to Bengali. Now, in 10 years' time, when the factories have moved away from mainland to Bengali, to Bangladesh, that would give our young lawyers a lot of opportunity because we are bilingual. But we need policy support to tap the opportunity. That's my observation. Now let me move on to views on a micro level. My association is an association representing youth legal professionals. Now this includes trainee solicitors or trainee lawyers and students. I've asked 21 barristers, solicitors, and legal trainees, and all of them gave me different views and different issues they have encountered. Our association is going to conduct a survey with 14 to 17 questions. 3 of them are open questions for gauging the difficulties encountered by our members on a micro level. Now, before the survey is conducted, I don't have a sufficiently large sample size to make a report to the panel. So after the survey, we will publish the results and the findings of the survey subsequently. So these are our views so far. Thank you.
Thank you. Second, representative from the Hong Kong Federation of Women Lawyers.
Members of the panel, legislative councillors, as well as the fellow speakers from the deputation. Thank you for the opportunity to address the panel today on the development of legal profession in Hong Kong. Based on the recent survey conducted by the Hong Kong Federation of Women Lawyers, I would like to present 3 key areas for improvement supported by the survey findings. Firstly, it is imperative that we enhance training and development within the legal profession. Our survey results indicate a strong need for comprehensive training programs that cover various aspects of legal practice, including emerging areas such as technology, cybersecurity, and international trade. Respondents emphasize the importance of lawyers becoming dual specialists, not just focus on one area, to better prepare for market changes. As an in-house for more than 15 years, I work at BlackRock as the head of legal, Greater China, and I've been practicing law for 25 years, coming up this year. I have seen many people who have been lacking sufficient business skills and other soft skills, such as communication and people skills. Therefore, apart from legal topics, the Law Society and the Bar Association can organize more courses for their members on subjects like tackling challenging conversations, building resilience, exploring team dynamics, and building effective teams, and addressing unconscious bias, just to name a few examples. Continuing education is also crucial. We must encourage continuous legal professional development through mandatory courses and workshops. The survey highlighted the need for training activities with other common law jurisdictions, such as the UK and Australia, to ensure our legal professionals remain up to date with the latest developments and best practices. Practical training should be emphasized through internship, moot courts, and clinical legal education programs. Providing hands-on experience will bridge the gap between theoretical knowledge and real-world application, preparing our legal professionals to handle complex cases effectively. Secondly, we must improve judicial service and digitalization. The survey reviewed dissatisfaction with the service level from the judiciary, particularly regarding the attitude of some judges and their lengthy processes. It is crucial that judges adopt a service mindset, recognizing their role in serving the community. We have heard feedback from members that for criminal cases, the waiting time at the magistrate level is usually acceptable within 3 months. However, for district court cases, it usually takes much longer, even for mitigation. For high court cases with a jury, the waiting time can be over a year after the committal hearing. For civil matters, the waiting time is always very long, especially for family matters, where the next first appointment can be half a year later. These delays are unacceptable and need urgent attention. Efficiency improvements are necessary to address these lengthy processes. Digitalization is a key component in this regard. Investing in digitizing judicial processes will improve efficiency and reduce the time required to complete legal procedures. The judiciary can consider more digital filing of pleadings, submissions, witness statements, and authorities. Many papers are duplicated, especially on core legal principles, and some documents can be over 100 pages long. Thirdly, we must expand opportunities in the Greater Bay Area. Our survey respondents suggested encouraging more young lawyers to take the GBA legal professional examination to enhance their understanding of mainland laws and competitiveness. Facilitating the professional development of GBA lawyers by providing resources and support is essential. One respondent mentioned that if possible, Hong Kong legal professional that passed the GBA exams could be could be issued a qualification certificate without the need to be attached to a law firm from the GBA. In conclusion, we need to cultivate a legal profession that is dynamic and adaptive, while strengthening our connections with the mainland and the Greater Bay Area, as well as other common law jurisdictions. Thank you for the attention.
多謝。第四位嘅團體係
The fourth deputation, well, the third deputation is from Asia Pacific Law Association. Thank you. Chairman, Legislative members, colleagues, Dr. Horace Chang, Deputy Secretary, good afternoon. The Asia Pacific Law Association was established in 2001. It was the first time that we were invited to attend the AJLSP. I am deeply honored. Let me spend some time to talk about our association. Asia Pacific Law Association is headquartered in Hong Kong with the 4 cross-strait regions, namely mainland China, Hong Kong, Macau, and Taiwan, as the core of our foundation and its outreach to the Asia Pacific region. The objectives of our association include providing a platform for interaction and exchange among legal professions in the Asia-Pacific region, promoting networking and understanding of the legal profession in the Asia-Pacific region, and promoting and supporting the long-term development of the legal profession in the region. I think that the objectives of our association is highly consistent with today's topic, that is, promoting the development of the legal profession in Hong Kong. Let me share with you our plan for 2025. With a vision and goal of building an international legal organization in China, the association in 2025 will, first of all, promote and strengthen exchanges and cooperation with the legal profession in the 4 places across the Taiwan Straits, especially with the legal profession in Taiwan. Because of political interference, exchanges and cooperation between the legal professions of the 2 sides of the Taiwan Straits, including Taiwan and Hong Kong, have been at a standstill for more than a decade. The recent unfortunate death of a famous Taiwanese artist, Miss Barbie Hsu, has highlighted a number of legal issues arising from the cross-strait people-to-people exchanges. For example, what are the arrangements for the guardianship and custody of Miss Barbie Hsu's minor children born to her ex-husband in China? What is the legal application of the inheritance of her estate under cross-boundary marriages? There's also room for cooperation and innovation and technology, especially in areas such as chips and artificial intelligence. The cooperation between TSMC and China is not a myth. For us to develop ourselves into an international INT center, we need to strengthen exchanges and cooperation with the mainland and Taiwan. But we have to prepare ourselves for potential sanctions. What role can the legal profession play in this area? What protective measures and solutions can the legal professions of the 4 places on both sides of the Taiwan Strait provide? I hope to explore and think about this with my fellow practitioners. Second, we're planning to explore and develop new markets and new areas together with the fellow practitioners. Due to geopolitics, the US-China trade war, the Trump 2.0 war, we are faced with unprecedented international chaos, which poses unprecedented challenges to Hong Kong, including the legal profession in Hong Kong. We have our traditional strengths, such as our proficiency in English and our common law system. We have to explore new strengths, however. We think that the basic function of the legal profession is to uphold the spirit of the rule of law, justice, fairness, and impartiality, regardless of which system we adopt. Legal practitioners should uphold the legitimate rights and interests of their clients in accordance with the principle of the rule of law. In 2025, our association is planning to set up an office in Xinjiang, pilot free trade zone, which will serve as a platform for exchanges and cooperation between the legal profession and enterprises in some Central Asian countries, such as Kazakhstan, Turkmenistan, and so on. We're actively organizing or reaching out to our counterparts in Northern Asia, including Mongolia, Southeast Asia, including Indonesia and Malaysia, to liaise with the legal profession and enterprises in these countries. This is a long-term systemic project that will require a lot of determination, manpower, and resources. We are headquartered in Hong Kong, and we are part of China. We need substantial and strong support from the Hong Kong government, and we also need the support of our country. We welcome those who share our aims and objectives to join us. May I wish you good health and a prosperous years of the snake.
嘅就係全球華語律師聯盟。
Next, Global Chinese Speaking Lawyers Association, GCLA, Chairman Dr. Horace Zhang and members of the panel, as well as fellow legal professionals. On behalf of the GCLA, I would give the association's views on how to promote Hong Kong's legal professions development. The 14th Five-Year Plan gave Hong Kong 8 clear positionings as a major entryway to the country's market. Besides integrating with the national development blueprint, the national strategies also gave a direction for Hong Kong's legal professions development. Now, 2025 is going to be a year of reaping fruit for our profession. We need to think about how we can tap the opportunities in the year. Now, there are 3 views. Each of the 8 positionings focus on our international positions. To develop our legal profession, we must be aligned with the international standards. Most of our law firms are of small to medium scale. Without international competitiveness, they can't tap the overseas markets. Now, of course, SMEs law firms have their roles to play. However, the problem is not with the market. Under our law, lawyers cannot practice under a legal entity that stunted the growth of our legal professions. Now, the legislative proposal was introduced a decade ago. However, the law is still not amended. This operational model has become an international trend. So I think it is time for Hong Kong to change the law so that lawyers can practice under a joint cooperation model. Second, with the GBA legal developments, we have a batch of lawyers who can practice on both sides of the boundary. However, there are still a lot of restrictions because of different rules and systems. We still need time to iron out these wrinkles. Now, the main advantage of our legal profession is the highly competitive international dispute resolution capability. As the regional ADR center in the Asian Pacific region, and with the investments made by the government, we have achieved glittering results. To consolidate our unique role in the region, we should further reach out to Belt and Road countries. Many Belt and Road countries are not English-speaking regions. We can actively promote the use of Chinese as a language for dispute resolution and showcase our unique strength. Several weeks ago, the country's own DeepSeek AI was launched. It shows that the threshold for developing AI has become much lower. Now, the government, rather than developing an AI platform for the legal trade, should consolidate and gather the available technological resources in the market to become the one-stop platform for promoting the services of our SME law firms. The government should also promote the trade to learn AI and similar technologies at full speed. We hope the government and the professional bodies can put more focus on AI adoption by the trade. Thank you. Next, Hong Kong Maritime Arbitration Group. Chairman, Dr. Horace Cheung, members and colleagues, good afternoon. I am Li Lianjun. I'm pleased to speak on behalf of the Hong Kong Maritime Arbitration Group. I also thank the HALSP for inviting the association to speak. I'm a senior partner of a local law firm and the director of the marketing section. I'm also a founding member of another legal body. Now, the Hong Kong MAG was established in year 2000. And since then, we have become part of the Hong Kong maritime legal profession. We became an independent body several years later. Our members comprises mediators and arbitrators. Now, we have played a part in developing Hong Kong maritime law in Hong Kong. The Hong Kong MAG's membership is open to all Hong Kong citizens or permanent residents in Hong Kong. Those who are interested in maritime law with an experience in the sector are welcome to apply for our membership. In 2020, October, the largest maritime organization, BIMCO, published the BIMCO Legal and Arbitration Clause 2020. For the first time, Hong Kong has been listed one of the 4 designated arbitration seats together with New York, London, and Singapore. Now, under BIMCO clause, parties can choose to apply our rules in arbitrations. Our rules have been recognized by the London counterpart as well. Now, allow me to share some encouraging reports concerning our maritime law development. Now, in terms of maritime and trade, we urge the government to step up dedicated talent trawling for the maritime legal profession. Now, these talents mainly come from vessels, maritime law, maritime commerce, and maritime management in universities in the mainland. Now, other universities, for example, the Dalian Maritime University and the Shanghai Maritime University should also be included. And also, master's degree holders in maritime law from abroad, for example, graduates from the University of Southampton and Tulip University in the USA. Now, the University of Hong Kong plans to establish the master degree for maritime law and maritime business in 2025. Now, together with the relevant universities in the mainland, for example, Shandong Maritime University and Dalian Maritime University, cooperation agreements should be signed. Now, besides, except Hong Kong, all other mainland cities have their own school for nurturing maritime talents. We can't lag behind. We need to provide stakeholders in the mainland with our maritime legal services. We are the only common law jurisdiction in the country. We should enhance collaboration with our mainland counterparts. Now, even for cases with no external or foreign factors, we should talk to the central government to allow these cases to be tried in Hong Kong. Now, finally, the Law Society, the Bar Association, and the Hong Kong Association for Shipping should form a promotional board for maritime arbitration in Hong Kong to promote our arbitration services to stakeholders. Finally, we should study offering our legal resources on aligning our aviation and maritime standard with the international community. Sixth, the government should work closely with the central government to leverage on our unique strength and also secure financial and manpower support from the mainland authorities. Thank you. Thank you for your views. Next, Hong Kong Maritime Law Association.
And also the Chief Secretary, Secretary of Justice, and it's my honor to be here to speak on behalf of the Hong Kong Maritime Law Association. We are a local law association in Hong Kong. We have got a long tradition of it being not just a local law association, but also an international, to be affiliated with various international law associations. It is our tradition in the past that the Maritime Court in Hong Kong to be the chairman of our association, including Judge Wang, Professor Reyes, and now Mr. Judge Anthony Chen as to be a chairman. And Hong Kong is a maritime hub, and also in the national level as the international shipping hub, a transportation center and logistics center. And in this regard, I would say on behalf of the association, that we would like to have a practice in multiple jurisdictions. The practice in multiple jurisdictions in the sense that it's not just legal practice, but also arbitration practice in multiple jurisdictions. What I mean by legal profession in multiple jurisdictions is Hong Kong is a common law jurisdiction. Hong Kong used to be, and it should continue to contribute to the development of the common law system jurisdictions, so that it can, because of its heritage, of its common law heritage, is still using the UK law, and also we have got make references to other common law authorities. So in the development of the common law jurisdictions, we have got used to have very important cases in the past that contribute to the common law development. And now we have got the Court of Final Appeal with the judges coming from the top rank of the other common law jurisdictions. And therefore, our standard is at par with the other common law jurisdictions. So in terms of development of practice, I think in Hong Kong, not just in Hong Kong, we should also, with our eye, not just in Hong Kong, the nearest common law jurisdiction is Singapore, and also there are other common law jurisdictions, not just in the UK, but also in the smaller jurisdiction like the British Virgin Islands. I've noted that some of my colleagues are also not just have got license to practice in other jurisdictions, including the British Virgin Islands and also Cayman Islands as well. Of course, those common law jurisdictions law firm has also got their presence in Hong Kong. And another area which I would say is the practice in multiple jurisdictions, of course, include the Hong Kong and the mainland. The mainland is of course, is the GBA area. But also, I would urge that it's not just the GBA area, but also it should be widened to a national-wide practice, and not just in the GBA area. And also the restrictions of practice in the mainland should be further lifted so that the Hong Kong practitioners can be able to further its presence and also involvement in the legal development in mainland China. And apart from that, the legal practice, the third area I would like to say is about arbitration practice. In the maritime law itself is a specialized area, and Hong Kong has got a long tradition of its being not just the maritime hub, but also the maritime law hub as well. Just as my colleague Lin Jun has just mentioned about the maritime law development, but also the maritime law arbitration development. It's not just the London to be the world center in terms of maritime arbitration, but Hong Kong should take more involvement, especially with the backing of the mainland hinterland. And so, in summary, I would say that we should not just focus on our internal market, but also international market, and of course, including the mainland market. Thank you very much, Mr. Chairman.
Thank you.
Next, we have representative from EBRAM International Online Dispute Resolution Center. Chairman, Legislative members, Dr. Horace Chung, Deputy Secretary for Justice, and teams from the DOJ, good afternoon. I am a practicing lawyer. I'm Ronald Sum. I am a Deputy President of the EBRAM International Online Dispute Resolution Center. Let me introduce to you what EBRAM is. We are a law tech firm. We help the trade in developing online storage and search platforms. We are a arbitration center, dispute resolution center, and we are the only online dispute resolution center in APAC. I'd like to talk about two areas. First, local matters, and second, international development. Now, first of all, thanks to the Department of Justice, EBRAM has become the designated dispute resolution center for certain government departments. Mediation has become a trend in Hong Kong. I think that we can promote it to all government departments or even commercial enterprises. I've been practicing as a lawyer for so many years. I think that mediation offers convenience to people, and online dispute resolution is a more efficient and effective way to resolve disputes. Now, in terms of arbitration, I think that we should promote online mediation to sports, to commercial disputes, or even arts disputes. That is, commercial disputes relating to arts and culture. So much about the arbitration. Second, on appointing authority. We are the only appointing authority under the International Organization for Mediation. I think that there can be more than one appointment of authority in Hong Kong, not just HKIC. That is the Hong Kong Mediation Center. I think that there can be more than one appointment authority. We've asked different lawyers online, including mainland arbitration centers and clients. They think that there can be more than one appointment authority. It doesn't have to always be Hong Kong International Arbitration Center. It can be EBRAM. Second, internationally, I think that we have to accept this fact. As mentioned by other practitioners, we are faced with sanctions. There is geopolitical disputes. We can develop online dispute resolution in not just Southeast Asia, but also countries along the Belt and Road Initiative and the Middle East. We've been saying that we want to try to help mainland enterprises go global. We want to facilitate their investment in the Middle East or Middle Asia. For these enterprises, they need online dispute resolution because investment inevitably results in disputes. Arbitration is a cheap, efficient, and effective way to resolve disputes. Thank you. Next, Hong Kong Law Society. Good afternoon. As mentioned, the Hong Kong Law Society is a self-regulatory organization. Please turn on his microphone. The speaker is off mic. The Law Society has contributed much to the development of the profession. I cannot detail them all in the interest of time. I'd like to highlight 5 points. First, on solicitors' cooperation. There is sole proprietorship, partnership, and limited partnership. in Hong Kong. We also have Lawyers Corporation. In early 2024, we have submitted regulations on Lawyers Corporation to the Department of Justice, and it is said that they will scrutinize our proposal as soon as possible. After that, we'll be able to offer an extra option to the profession, and this is conducive to the development of the trade. And we also submitted a proposal to the DOJ last year on CPER arrangement. We propose to expand the provisions to lawyers' corporations so that they can enjoy the favorable arrangements under the CPER agreement. We hope that the proposals can be implemented as soon as possible. Second, exploring new opportunities. The Law Society have been trying to come up with new areas of development. The sports industry amount to some $600 billion. Various legal matters such as intellectual property, broadcasting rights, sponsorship, manager agreement, drugs, so on and so forth. I attended 2 meetings in Paris that talk about the development of the sports industry. The Law Society has been promoting sports law to the trade. In 2024, the Law Society submitted a proposal to the government on the development of sports law in Hong Kong. The government accepted the proposal, and that's become one of the measures under the 2024 policy address. The government supports the implementation of the pilot scheme on sports arbitration in Hong Kong. Between 20th to 23rd of February, we're going to organize a large-scale event covering Sports Summit and the 9th GBA Sports Day. Sports Law Conference is the first international forum that focuses on sports. The theme is Be Just, Be a Good Sports. There will be leaders from the trade, legislative members talking in the forum. We have speakers who are senior counsel from, say, Paris and other countries to speak. We want to promote the deeper understanding of sports law among the trade. The Law Society have been trying to create a more favorable environment for the trade. We have 36 experts committees that advise the government. Some of the things that we're working on include the establishment of finances and infrastructures for intellectual property rights. And the Transport and Logistics Committee under the Law Society is discussing laws on electronic bill of lading, and we're going to submit a proposal to the government. The Transport and Logistics Committee has been talking to the government on LTO and the application of it. With the expert committees, we have submitted our suggestions on the 2025-26 budget on 6 different areas, including asset and wealth management, transport and logistics, intellectual property, sports, entertainment, arts and culture measures, as well as other financial measures. The law trade should be able to offer relevant support services in these areas. Third, we want to enhance efficiency and effectiveness. We have published our stance on AI, and we have collected views from the practitioners to learn about how they apply artificial intelligence in the duties or work. The Law Society also established a Hong Kong Academy of Law, and this is one of our key focuses in 2025 that cover artificial intelligence and law tech to enhance the professionalism in the trade. The Law Society also submitted various suggestions to the DOJ, say ICMS, Apart from electronic storage of documents, we propose to offer electronic delivery of documents, and we think that the courts should implement voice-to-text technology more speedily so that the court proceedings can be more smooth. Also, on the sustainable development of the legal trade. Young people is the reason why we have a sustainable trade, and this is one of our focuses. Some of the examples include, well, I actually visited England in October 2024, and I attended a student event on exploring a Hong Kong legal profession. A lot of students attended the forum, and they said that they had planned to come back to Hong Kong and practice. We also have other flagship events, including some talks and forums that educate the students and enhance their interest in joining the profession. We also established a common law center, which is a training organization. This common law center systemically implement the education of common laws and offer relevant courses to those who are interested to join the profession and to contribute to the development of our country. Rooted in Hong Kong and expanding to the world, the Law Society have forged a great relationship with various law associations around the world, and we have signed a number of memorandums of understanding with 29 jurisdictions and 44 law associations. We have signed altogether 47 memorandums of understanding. In May 2024, together with Dubai Financial Center Court, we signed a cooperation agreement. Together with the Middle East court systems. Sorry, the time limit is 5 minutes. Please observe it. Chairman, my speech is about to come to an end. Lastly, we want to facilitate the development of our young people. Next, Bar Association of Hong Kong. Thank you, Chairman. There are 1,700 barristers in Hong Kong. Apart from handling legal proceedings, they also work on arbitration and mediation. I think the DOJ and the Hong Kong SAR government, including, well, as well as Trade Development Council, for their efforts in developing legal services in different places, such as the mainland. We will seize various opportunities brought to us from the development of the Greater Bay Area. The legal profession in Hong Kong is highly internationalized. We have lawyers from South Korea, Singapore, who have joined the legal profession in Hong Kong. This is conducive to the development of our city as an arbitration center. The Bar Association will adopt different ways to promote the legal services of Hong Kong and to tell our story in other places. Our barristers is trained in the common laws. They are trilingual, and they are well versed in the culture of the mainland. The Bar Association will continue to offer training on arbitration, will organize talks to support the development of the trade.
Thank you. Any other representatives from the Bar Association? Thank you, Chairman. I will talk about how we can further enhance our mediation and arbitration legal services. From my observation, we have three major strengths. We always say that Hong Kong is the only common law jurisdiction in the whole country. This is special, but we still need to put emphasis on our special strengths to promote our services to overseas clients. As others have said, most legal practitioners in Hong Kong can provide services in 2 or 3 languages. This is a real strength that other similar common law jurisdictions don't have. This is particularly attractive to potential customers in the mainland and overseas clients. For those who choose Hong Kong as an arbitration seat, the language proficiency of our lawyers is very attractive, so we need to put emphasis on this unique strength. Another unique strength, as mentioned by the chair, is the knowledge and understanding of culture, especially business culture, of our lawyers in the mainland. This is unique. This knowledge, the knowledge of lawyers in other common law jurisdictions on business culture in the mainland cannot compete with those our lawyers have. When doing business with mainland partners, our lawyers' understanding of the business culture in the mainland will definitely help the clients. The final unique strength is the enforcement of arbitration or arbitral awards awarded in Hong Kong. With the mutual enforcement agreements signed with the mainland, arbitral awards awarded in Hong Kong is not only enforceable overseas, but also in the mainland. This will put our overseas clients at a great position against other parties in the mainland. So I suggest that in the future, publicity campaign, besides our strength as the hinterland, with the country as our hinterland, we should also focus on the 3 strengths I have mentioned above. The government should work with the trade to convey a clear message to our potential clients in the mainland and the world. Thank you. The Bar Association has finished speaking. Now I will also invite Ms. Maggie Chan to speak on behalf of the Small and Medium Law Firms Association. I declare interest. Besides a council member, I'm also the founding chairperson of SAM Law. I'm also authorized by the SAM Law to represent the trade's views on the sector. Now, SAM Law is a non-profitable organization. We seek to enhance the operating environment for the legal profession and uphold the rights of lawyers. So I thank the AGLSP and also the DOJ, as well as the Bar Association, Law Society, and other stakeholders for contributing to the developments of the trade. The first point I would like to make here is a survey conducted by SAM Law last year. 646 questionnaires were collected. The question is about the operating cost of law firms in Hong Kong. Now, the findings show that the operating cost is prohibitive. Rents and other operating costs have added burden to law firms. Now we have to pay premium fee for professional indemnity insurance. More than 86% of the respondents think that the insurance premium should be reduced. More than 83% of the respondents think that the professional indemnity insurance should be opened to more insurers to enhance competition and lower the cost. Now, concerning foreign-related law expenditure, I have been told that in terms of inheritance of estate or cross-boundary certification services of will, the fee is highly expensive. More than 93% of the respondents considered that the fee related to check the register and publish a notice is too high. It costs as much as $5,000 for each notice published. Now, for grassroots people who would like to initiate the inheritance procedure in the mainland, the cost is highly prohibitive. It also drives down the cost competitiveness of our services. So it is our members' wish that the $5,000 fee for inspecting the estate registered be lowered. Now, about practicing in the GBA, I thank the GBA for providing a platform for communicating with the GBA legal sector. We have heard views from young lawyers in the mainland that they don't fully understand the difference between barrister and solicitors and their respective roles. Some young lawyers would like the DOJ and the stakeholders to promote the role to be played by barristers in the GBA. Now, whether it is barrister or solicitor, everyone is just experimenting how to be involved in the mainland business. And they have also been trying to reach out to overseas markets to engage in foreign-related matters. So since we have the GBA lawyer platform set up, we hope that the progress would go faster. Now we hope the DOJ can work more closely with the Judiciary so that the ICMS system in court can be established more effectively. This will reduce the cost of the trade. Now, because of the downward economic pressure, a lot of SME law firms are struggling to stay afloat. So this is a difficult time for everyone. I hope SME law firms in Hong Kong and also young lawyers and barristers can get more help from the government. Thank you for your candid views. Last, we will have the Hong Kong and Mainland Legal Professional Association. Thank you, Chair. I have 4 points to make. First, we should have a regulatory system for non-practicing lawyer in Hong Kong. Now, in the mainland, there is so-called lawyers who doubled up as government lawyers and corporation lawyers. A license would be issued to them to ensure that they are engaging in continuous education so as to keep abreast with time and continue to contribute to society. In-house lawyers are snowed under with their in-house works. If there is not a licensing system with no CED requirements, they will not get any support from their corporations for them to engage in continuing professional development. So the government should start by leading as example and then implement the rules in listed companies. Now, the CPD standard can be less stringent, but this will give the lawyers a sense of getting the support they need. At this moment, for non-practicing lawyers, they don't need a license to do their job in Hong Kong, but we should make reference to the mainland model and regulate these lawyers as well. Now, our statutes lag behind the development of technology. So the DOJ can step in and take the lead in involving more lawyers to develop our legal system. More lawyers can be absorbed into government's advisory panels. I think a lot of lawyers are interested in offering their views to the government. 3, dispute resolution. In paragraph 47 in the policy address, Hong Kong's objective is to become a regional sports dispute resolution center. So I hope we can get more support from the government and society in pursuing this direction. I fully support the pilot scheme on community and sports dispute resolution spearheaded by the government. Now, the ALLCO has attracted many experts in sports dispute resolution. Now, in the upcoming Asian Games and National Games, our lawyers are ready to offer their services. However, most NSAs do not have the resources to seek legal services. So I hope that we can get more support from the Financial Secretary in the upcoming budget. Now, to develop the trade, we need sustainability and new blood. So besides the existing PCL framework, I hope we can get more support for the Law Society's examination. I have been on the panel for Scarlett for a decade, so I hope the government can give us more support so that we can present something to society. Thank you. Next, I will open up the floor to members who would like to speak. Please press the button. I will first invite Dr. Horace Cheung to give a consolidated reply to the views put forward by the deputations just now. Thank you, Chairman. I thank the HLSP for giving us this platform to canvass valuable views from the trade. Now, I may not be able to address each view in length. Still, I would like to share our positions on some of the views put forward just now. Now, I'm pleased to hear from the young lawyers saying that U.S. clients are still choosing Hong Kong as an arbitration seat. That's because of the strength of our legal talents. They have vast experience in international business dealings. They are trilinguals and they have common law upbringing. Now, there are other strengths which highlight our advantages as well. Now, some may worry that after 10 years, when factories have moved away from the country, we will still be favored by overseas clients. I don't think we need to worry because factories have moved out from Hong Kong a long time ago. Now, in terms of interim measures of arbitration, we have great strength. I'm talking about the interim measures arrangement signed between Hong Kong and the mainland. Now, that's for arbitral proceedings held by recognized or designated authorities. If the other party seeks to destroy evidence or move away their assets, we can apply for interim measures with the mainland courts for preservation of assets, evidence, and conduct, so that the arbitral award can be enforced in the future. Now, this is our unique strength, and it is only made possible with the support of the country. When I visited Netherlands and also the International Arbitration Organization in Hague, I was asked by the Secretary General whether they could have a similar strength like Hong Kong's interim measures. So we need to keep up with our good work. As long as we work hard enough, we don't have to worry about businesses going away. Now, maritime trade and maritime logistics have moved away from the UK, but still, London is the most preferred maritime arbitration seat. That's because of the historic strengths of the city.
嗰個建議咧就話我哋要
Another great suggestion is that we should promote and develop in countries along the Belt and Road Initiative. Within this year, we have plans to visit Middle East Asian countries to promote our strengths in arbitration and mediation services. Last year, I reached out to countries in Central Asia, such as Kazakhstan. They also have a common law center. They want to connect with international common law jurisdictions. A lot of these Central Asian countries have a harmonious relationship with our country, and there is frequent trading among these countries and our motherland. So I think that these are the opportunities that we can leverage. When we have more progress, we will update the members. Hopefully, we can invite more practitioners to join. Now, on the application of law tech, it is one of the key policy measures set out in the policy address last year. Chairman, this morning I chaired the first meeting of the working group on law tech. We had representatives from the two legal professional bodies, professors from universities, and trade practitioners in the law tech field who joined the first meeting. As the deputations subside, we will first let the trade know what law tech is, and we have to identify law tech products in other countries, or mainland and Hong Kong. Because under one country, two systems, our laws, we adopt a common law system. The law tech on the mainland may not be applicable in Hong Kong, but some of them may be cost-effective, say DeepSeek. We have to explore different products. And we'll also work on education, and we will explore products on the market. And we'll also try to manage risk involved in the adoption of law tech. When the time is right, we will come back to this panel to report to members the progress of our work in this area. Now, in terms of maritime law, the trade won the government to develop in this area. I noticed a recent debate a motion debate in the Legislative Council on maritime law. The Secretary has talked about what we've done on nurturing maritime law or legal talents, and we have a fund on nurturing maritime talents. And we work with Shanghai Maritime University, Dalian University. We subsidize some of their students to take relevant courses in Hong Kong. And in September 2023, the fund offered a subsidy scheme on maritime arbitration training and offer internship opportunities. These may not be enough, but we're working on it. We also have something in the pipeline. Some deputations ask if we will promote our maritime law services in other places together with some trade practitioners. We are planning for that. In the future, hopefully we can organize these visits. And by then, I hope that the legal trade will support it. Well, on sports arbitration, I thank the two legal professional bodies for their strong support. I thank also the Culture Sports Bureau. We have organized a meeting, and very soon we're going to identify the right arbitration organization to offer such services. And within this year, we hope to be able to identify the right arbitration institutions, and then we can formulate sports arbitration rules and come up with a list of arbitrators. We'll work with the national sports associations when there's disputes arising from the management of NSA. We can handle them through arbitration. There is also commercial business related arbitration, such as disputes on tickets, broadcasting rights. There are business opportunities in these for the legal trade. I hope that the sports arbitration institutions will be identified soon. One more point, as mentioned by Ms. Maggie Chan. I've heard from GBA solicitors. She asked that we also attach importance to barristers, and we should allow barristers to also practice in the Greater Bay Area. Well, during our duty visit to the Greater Bay Area, we were joined by barristers and solicitors. But what business can barrister engage in on the mainland? Well, barristers, some of them are qualified to become arbitrators, and in the list of mediators, we also have barristers. Also, under the measures of allowing Hong Kong invested enterprises to choose for arbitration to be seated in Hong Kong, the mainland courts will need to have a deep understanding of the Hong Kong's laws, and the barristers assisted in providing relevant advice to the mainland courts. So there is great business opportunities in this area, and we hope to develop it so that both solicitors and barristers can develop their business in the Greater Bay Area and contribute to the GBA. so that we can achieve the objective of having this GBA legal framework. Thank you. Now I invite members to speak on the deputation submissions. Well, there are 6 members who have pressed the button. I'll read out the names of the members who have pressed the button. 4 minutes per member, including question and answer. Now I'll read out the names. Ms. Carmen Khan, Dr. Junius Ho, Professor Priscilla Leung, Mr. Holden Chow, Ms. Doreen Kong, and Ms. Maggie Chan. Ms. Khan, thank you. Thank you, Chairman. I have to declare interest. I am a Deputy Chairman and a member of the Hong Kong Federation of Women Lawyers, and I am consultant of the Asia Pacific Law Association. I have 3 questions. First, on the promotion of exchanges in 4 places across the strait, especially in mainland, what is the plan of the government? Second, well, my second and third questions are for the Judiciary. Hong Kong Federation of Women Lawyers have conducted a study, and they think that there is an urgent need to reform the legal profession. Say, for example, the waiting time for civil proceedings is very long, and they think that the time taken for these legal proceedings is unacceptable. I'd like to hear about the progress of reformation. Also, on the mode of operation of Lawyers Corporation, I think that we are lagging behind as a city. I think that we have to catch up. I wonder how far we've gone. If there's time left, I'd also like to hear about the enforcement of mutual recognition of decisions in civil and commercial matters. Thank you. Ms. Khan, the topic of discussion today is the promoting the development of the legal profession in Hong Kong, but not on reformation of the reformation of the judiciary. I will ask if the judiciary is willing to take the question. Well, perhaps first of all, let me ask the DOJ to address the first question. Thank you. On the exchanges in 4 places in the community level, we support it. We have organized various exchanges and activities that facilitate exchanges in the legal profession in 4 places, and I was a part of all of these activities and events. At local universities, we also have exchanges on civil and contract laws. We have invited scholars and professors from Taiwan to attend these forums. I attended these activities as well. So we definitely support this form of exchanges. So apart from attending these events, I hope that there will be some sort of fund or concrete action to subvent the trade, to carry out more exchanges.
司法機構嗰邊咧，你可以
Now, Judiciary Administrator, maybe you can focus your answer on promotion of developments of the legal sector in Hong Kong. Thank you, Chan. Thank you, Ms. Khan, for your questions. Briefly on court waiting time. In the previous document, we have set out that by the end of 2024, overall speaking, waiting time for civil cases was on target. It's only for complicated cases that we needed to deploy more manpower to shorten the waiting time. there was significant improvement. However, waiting time for criminal cases is still long in district and high court level. For cases with public interest, these cases are still being deferred because of insufficient manpower. However, with the latest round of appointment of judicial officers, the manpower situation should improve in the next 2 years. We will also pick up pace on application of technology. We thank the legal trade for their support in the adoption of law tech, for example, e-bundles. This will help us improve the overall efficiency of courts' operations. Now about allowing lawyers' cooperation as one of the model of law firms in Hong Kong. Now we have received proposals from the trade several years ago. The Chief Justice is now scrutinizing the proposal. Now the objective is to enhance development for the trade while protecting consumer interest. We will pass on our views to the DOJ and to the trade as soon as possible. Thank you. Next, Dr. Julius Ho. Thank you, Chair. I have 2 questions. It has come to my notice that the DOJ is promoting arbitration and mediation in Hong Kong. That's great. Especially mediate first. This is a culture that we should respect and promote. We often see parties getting very worked up in court. That also leads to the long queues in the courts. Now, should we amend our civil procedures to require case managing judges to advise both parties to seek mediation first before it goes to trial? But there should be a case management conference. For these cases, the judge would advise the parties to try mediation first. Since that is the case already, can we go even further to promote the adoption of mediation? Second, on arbitration, according to the New York Convention, 137 jurisdictions have signed the convention. Now, we have been focusing our promotional efforts in the Belt and Road countries. So how are Belt and Road countries doing in terms of adoption of the New York Convention? Now, by reaching out, we may be doing business in Kazakhstan and other Central Asian countries. So the 137 signatories under the New York Convention can have the arbitral awards enforced mutually. So what about the OBOR? Under that initiative, is there a clause for enforcing arbitral awards awarded in other jurisdictions? Secretary, 2 questions. On the first one, more aggressively promoting mediation in court proceedings. Now, as far as I understand, like Dr. Janice Ho mentioned, before trial, parties in civil cases involving personal injury or family cases, the judge would advise the parties to try mediation first. Whether we can go further depends on the procedures for individual cases. So we need to explore this possibility with the judiciary. This is not something that the government or the DOJ can initiate from a policy point of view. But we will do anything to promote a mediate-first culture in Hong Kong. That's why, internally, in the government, we have promulgated a policy statement to pledge that in dealing with disputes, government departments have to seek mediation first. The mediation template or mediation clause has been shared with government departments. We have briefed government departments in adopting the mediation clause. Now, unless for very complicated cases, all government departments would seek mediation first in case of disputes. So I hope the private sector would also embrace the initiative. This will give us more momentum. Now, about the compatibility between the pledge and the New York Convention. It really depends on the individual circumstances of the targeted market. Now, the Transport Department has visited Kazakhstan, and a similar agreement has been signed with the Kazakhstan government. Under the Belt and Road initiatives, there are a lot of countries, and they have their own distinct characteristics. So we will give play to Hong Kong's leveraging role for the country's Belt and Road initiative, but I can't tell you specifically how we're doing in certain countries. Professor Priscilla Leung, I'm pleased to see fellow members from the legal profession here. Now, all of you here have been working very hard for the past decade so that we have the achievements today. So I would like to thank all the fellow stakeholders here. Now, since the Lehman Brothers incident in 2008, we dearly felt the dire need for mediation in the public. At that time, mediation still hasn't gathered momentum. Now we have secured the establishment of IOMED in Hong Kong. That's down to your efforts. Now, just this morning, I saw from the news that the Turkmenistan's sport players have injured our own players. So how can we resolve this dispute? It's better if the case don't go to court. It's better to have mediation first. But mediation takes time. For those who are involved in mediation, you would know that everything is about procedures in mediation. Now, I have spent 30 years in universities teaching law. I have taught many young lawyers. I'm very confident that many of my students would be interested and passionate with sports dispute resolution or mediation. But in terms of maritime law, like Ms. Li Lianjun said, many young people think that maritime law is a very boring business. So no matter how many scholarship award you offer, you the student enrollment in the course may be underwhelming. So maritime law is a very important area of Hong Kong's development.
The field, it can be big money, right? 所以呢，就係
Now, sports and maritime, there's very different levels of interest in these two fields among the youth. So I like what Mr. Tang said. I share your view. IPO number is underwhelming, but there is a lot of cases and demand in terms of restructuring of business and winding up. I declare interest. I'm a lawyer myself. I have a GBA practicing license. I was also involved in legal research work in the Bay Area and Qianhai. I think our hands are tied, and it restricts us from tapping the opportunities in the Greater Bay Area. Now, barristers should collaborate not just with solicitors, but also other professionals. Now, corporate restructuring, that is great business. We have great potential in the business. So we need to open ourselves up even more. It's great that we are trilingual. But in terms of allowing foreign lawyers from practicing in Hong Kong and the GBA, the level of integration is insufficient. We need to bring talents together. The change in the world will bring great opportunities for Hong Kong if we position ourselves correctly. So I hope the Bar Association and the Law Society would loosen up your restrictions, especially the Bar Association. Now, law firms would refer clients to each other. International business in the field of corporate restructuring and winding up is huge. So first, maritime law, and second, liquidation and winding up procedures. We have a shortage of talents in these two fields. So I think the law firms, the professional bodies, and our universities should plug this gap. Now, London is the leading city in the world in terms of corporate restructuring and mergers. Now, Singapore is catching up with London as well. We have to catch up too. And we need to offer a one-stop service for the clients by collaborating with other sectors. The cake is huge. So that's what I want to share with the members. So all of the above is your views, correct? But I welcome a response from the secretary or the professional bodies. Mr. Holden Chow.
Thank you, Chairman. I'm glad to see so many practitioners of the trade here. I see that you have contributed much to the development of the profession. Let me talk about one single area. That is maritime law. I see that more courses on maritime law have been offered by some universities here. But to be frank, there are only a few law firms that specialize in maritime law in Hong Kong. If we want to develop ourselves into a maritime trade and trade center, we need the relevant legal services. We have conducted the survey and collected some data for undergraduate courses in Hong Kong. Only Hong Kong U, CUHK, and the City U offer undergraduate modules on maritime law. And there are 9 altogether. For postgraduate courses offered by these 3 universities, there are 9 relevant courses. These courses cover different areas in the field of maritime law. Maybe we can introduce module on maritime law for undergraduate students. Or maybe we can create incentives for law students to take these modules. Because for students who have taken these modules on maritime law, they will be more likely to join the field. Please correct me if I'm wrong. It seems that maritime law is not a mandatory modules for law students. I think that in order for us to develop the field, we need to ensure that law students understand what maritime law is. Can we create more incentives to motivate students to take these courses? I see that the 3 universities are working on it, but it seems that still law students are not that interested in maritime law. Maybe we have to work harder on it, because this is one of the direction of development of our legal profession. That's a comment. Any reply from the judiciary? There are questions relating to universities. Mr. Moy. Thank you, Chairman. I thank Mr. Chow for his comment. I have one thing to add. Through the Standing Committee on Legal Education, the DOJ has been working on nurturing maritime legal talents. In a meeting of the Standing Committee, our representative talked about how we can enhance training on maritime law among our law students. Although the 3 universities offer such courses, they are not mandatory. We will relay Mr. Chow's suggestions to the Standing Committee and will follow on it. Thank you. There are still a few members waiting to speak. Our meeting was scheduled to end at 6:30 p.m. I'll extend it by 10 minutes first. Ms. Doreen Kong. Thank you, Chairman. I thank the members of the trade for coming. I'm glad to see you all. I have a few observations and comments. Well, first, I think that this is the great time for us to help our legal sector go global. We cannot wait for business to come. We need to help the legal sector go global. That's what we call export of legal services. Will the government allocate more resources to the trade for strategic study? In some other countries, they have a transformation map for their legal profession to help their trade transform and upgrade. For SMEs or a small and medium law firm, they don't have the resources to invest in other places. So I hope that the government will help the trade in transforming. Some members of the trade talked about digitalization just now. I think that we are lagging behind. A lot of lawyers want to work remotely. They want to work from home. But we don't have such software in a lot of the law firms in Hong Kong. We want to develop the common law. Can the DOJ offer secondment opportunities for young lawyers in Hong Kong so that they can be seconded in other common laws jurisdictions? Some deputations talked about rent for small and medium law firms, and that's an issue. Can we create a legal hub for small and medium law firms to rent an office in the legal hub for 5 to 10 years so that they can upgrade their business or work on innovations as a lawyers that focus on property? The government has not helped the trade in nurturing property lawyers. We are trying to develop the Northern Metropolis. I think that the government should cultivate and nurture property lawyers. Property lawyer is a part of the financial sector. After the financial crisis, we've seen a decrease in the number of property lawyers. But for partnership, I believe that in the coming 20 to 30 years, we're going to see professional companies that are joint ventures. And this such joint ventures may be formed between business and professionals. I've looked at Spain and Singapore. In the coming 3 years, they're looking into joint ventures between lawyers and accountants. I hope that we can consider this direction. 6 questions. Deputy Secretary. Thank you. Most of them are comments. We'll consider them. I can respond to some of the questions. Say, for example, whether we can offer more secondment opportunities for the trade. We do have such plans. We have sent government counsel to other common law jurisdictions or international legal bodies for secondment for a year. They can broaden their horizon and develop their people network. We also invite lawyers in the private sector to second in some other places. We interviewed them. Well, I visited them when I went to Netherlands, Italy, and I saw that they really have their horizons broadened after going through these secondment. Resources are scarce, but we want to try to offer more opportunities for young lawyers. Young lawyers are more willing to go on these secondment. For experienced and mature lawyers, they may not be able to leave their family or law firm behind. And we see that young lawyers are more willing to go to other countries and work. Well, on the point about legal hub, first, we don't have so much land to build an office estate for law firms. Second, the size of these offices may not meet the trade's expectations. And that's an issue. Now, on application of technology, as I mentioned, we've just had a meeting on the application of INT, on how we can help the small and medium law firms use technology. In a meeting this morning, some experts told us that we should not just help small and medium law firms, but also in-house lawyers. We try our best to help them. We'll also try to identify foreign products or products on the mainland, and we will also help the trade to develop software locally. On how we can encourage the trade to use technology, we'll work on that in the future. We hope to promote the use of law tech. Thank you, Ms. Maggie Chan. Thank you, Chairman. To declare interest, I'm a member of the advisory group on the promotion of law tech. Let me say a few words. The trade and I are looking forward to the government helping the trade lower costs and go global. Now, in terms of cost, in the meeting this morning, we talked about how we can develop a platform for use of the entire trade that allows for safe storage of documents and digital document applications, and how we can connect the platform with other jurisdictions. We also want to use this platform to deliver documents among different lawyers and barristers at a very reasonable cost. The legal trade needs to improve our infrastructures because ICMS is about to be implemented in 2026. So I hope that the government will offer tax exemptions for the installation of these infrastructures. I hope that the Deputy Secretary will talk to the mainland entities so that as long as GBA lawyers are involved, extra points will be accorded to the tender submitted for the government procurements on the mainland. Now on to the development of the Belt and Road Initiative. I hope that the Deputy Secretary will look at SMSC firms and invite us to go on visits with you, because SME firms are boutique offices. Some of us are experts, some of us are very much experienced. I hope that the administration will go on visits together with us. Regarding intellectual property and maritime laws, some lawyers don't know where to start. On the international, I see that the International Academy for Legal Talents have commenced operation, and a lot of mainland judges are nurturing talents on foreign-related laws. I'm not sure about how much resources we have. I hope that the Academy will try to enhance internationalization, diversity of our lawyers so that they can offer more services of different fields, say on maritime, intellectual property, so on and so forth. Lastly, I think that the reply given by the Deputy Secretary is very much consistent with what the trade is looking for. Perhaps that's because the Deputy Secretary has been practicing for a number of years. Thank you.
因為我哋嘅
The meeting has been extended to 6:45. I will now draw a line. After the Secretary's reply, I will only give the subsequent members 3 minutes each. Thank you, Chair. Ms. Maggie Chen gave us a ton of suggestions. I've written them all down. I will take on board all your suggestions. You will see changes soon. Considering helping SME law firms to go global, providing on-the-job training, or rather, offering value-adding courses to SME lawyers in terms of IP laws and so on. Now, maritime law, there is huge demand for talent, so we will reinforce our training efforts for maritime law-related talents at the university level as well. Thank you. Dr. Junius Ho. Now, riding on Maggie's question, there are some 13,000 lawyers in Hong Kong, but most of them work in small to medium law firms. Larger law firms have the resources to tap overseas markets. So according to the Bar Association, memorandums on cooperation have been signed with overseas partners. So with the government's body of Hong Kong International Legal Talents Academy, can the government take lead with the support of the two professional bodies? Can the government establish secondment arrangements with all the Belt and Road countries for our local lawyers? Now, back in 2003, with the PSDS, legal practitioners in the mainland have been given secondment arrangements to learn in Hong Kong. So this is how we can help the mainland law firms to go global. So we need to do the same for our own SME law firms. They need the governments to hold their hands to take them go global. Now, I've heard that the DOJ took 5 young lawyers to send 5 lawyers to learn in large organizations like the World Trade Organization. Now, with the joint efforts of the government and the professional bodies, we can make this happen. Secretary, thank you, Dr. Ho. The DOJ will do its best. But the DOJ alone is not enough. Secondment with the WTO, that was possible because of the help from the Ministry of Foreign Affairs. That's why we always say that we enjoy the backing of the country. Those secondment opportunities were only made possible with the support of the country. So we will work on it and report to members when we have progress. Next, Ms. Doreen Kong. Thank you, Chairman. I would like to talk about mediation this time. Mediation is useful, especially on resolving minor disputes at a regional or district level. We have been talking about developing the mediation industry for many years. However, the public is still unfamiliar with this concept. For specific areas like building management, can we implement mandatory mediation for disputes involving water leakage? Parties will have no choice but to try mediation first. Back in last November, there was a discussion in Singapore where mediation would be made mandatory for cases involving building management disputes. Maybe we can try mediation on a mandatory basis in some pilot areas to boost the public's confidence in using mediation in other areas as well. I will defer my question to Ms. Zheng. On that point, in Policy Address 2024, it was mentioned that we are preparing for the launch of the pilot scheme on community mediation. We will seek to equip certain stakeholders in the community with mediation skill. Training would be offered to these stakeholders for resolving community disputes. One suitable area is property management stakeholders. We are preparing the program as we speak. Thank you. Can we have some follow-up questions? I'm pleased to hear the answer from the government. However, voluntary is not sufficient. Disputes involving building management are complicated. It arises from a low level of mutual trust between the residents, so they will not choose mediation voluntarily. Maybe we can try making it mandatory for simple cases like water leakage. That may be more efficient. We have already drawn a line, and the meeting will be extended to 6:45. I seek members' views since the discussion is so enthusiastic. Would you like to extend the meeting for another 15 minutes? Thank you. Next, Professor Priscilla Leung. Thank you, Chairman. I need to clarify first. When I mention the shortage in maritime legal talent, well, the City University of Hong Kong established the first maritime law center in Hong Kong, but in the end, the director quit. Now, the market is huge. It is good for business. IPO, maritime law, and liquidation, these are lucrative businesses, but these fields are quite boring to some. You can't force students to choose these subjects. On the other hand, we need to broaden our horizon. We need to recognize these fields as lucrative. Now, I agree with Mr. Lien. This is very important in terms of internationalization of our business. So we can't make people choose the subjects. Second, I seek a reply from the Bar Association. Now, as a GBA lawyer, you need to be attached to a law firm. There are lots of criminal and civil cases referred to Hong Kong law firms and our barristers. But we also need a solicitor. So in order to get a solicitor, the client needs to engage a solicitor's firm as well. And then legal advice would be sought whether a senior counsel is required for the case. So this is quite inconvenient. How can we iron out the wrinkles and provide a one-stop service for clients requiring legal services? Now, I'm open to a discussion with the Bar Association, but can you loosen up the restrictions? Bar Association. Thank you, Professor Leung. Naturally, we would like to offer more opportunities to our members. At the same time, we need directions from solicitors. They are our partners, not competitors. So we need to strike a balance here. But I've heard Professor Leung's views. We will try to remove the shackles for our members. I know this is a sensitive issue because I'm also a barrister. But if you look at other jurisdictions, the separation or the divorce between the two trades are not that distinct. So can we try that with cases from the GBA? You don't need a barrister to be teamed up with a solicitor. This will save some back and forth between the clients and the solicitor firms. It would be a waste of time and money. Thank you. The last member to speak is Ms. Carmen Can. Thank you for accommodating me, Chairman. Also thank the stakeholders for your patience. My question is also about maritime arbitration. Mr. Li Lianjun mentioned that Hong Kong is one of the 4 designated arbitral seats designated by BIMCO that showcased our maritime prowess. There is also a pilot scheme to examine the working visa requirements for parties participating in arbitration in Hong Kong. So this pilot scheme, did it benefit the maritime legal sector? Second question, Secretary. The government is going to upgrade the Hong Kong Maritime and Port Board to the Hong Kong Maritime and Port Development Board. So riding on this opportunity, I hope the DOJ will also be involved in the development of the trade. Besides development of maritime law, that is the full life cycle maritime services provided by Hong Kong, like the motion moved by the chairman some time ago. We hope that the DOJ can be involved in the HK MPDB as well, efforts as well. Is your question directed to Mr. Li Lianjun or the Bar Association? Now, my first question was, did the pilot scheme actually benefit the maritime arbitration sector?
我觉得这个计划是对海事仲裁有。
I think that this scheme would be helpful, so I hope that it can continue to be implemented. My suggestion is that we should attract more lawyers to come and learn maritime law. Just now, I also talked about the fact that Hong Kong is the most preferred seat of arbitration. We need to promote our advantages. So I think that we have to promote it in Asia. through this pilot scheme, through the Hong Kong IAC, we do see the effectiveness of the scheme and the arrangement. For expert witness and solicitors or barristers, they're worried that if they don't obtain the employment visa, they will be breaking the laws here. So I think that the pilot scheme would facilitate our development into a arbitration center. Deputy Secretary, I will talk about maritime development. As Ms. Khan said, legal services is a part of the maritime and port development. Ms. Khan talked about the insurance and logistics industries and the legal services. We're just part of the entire chain. The authority is the Transport and Logistics Bureau. We'll pay attention to any news and will also offer suggestions to the relevant policy bureaus on how the legal trade can play a part in the development of maritime and port. Ms. Khan? Now we've heard the deputations. We welcome a written reply from the administration. I thank the deputations and representatives for attending this meeting. Any other business? There being no AOB, meeting adjourned. Thank you.